declares, among others, that we, the people of South Africa, believe that South Africa belongs to all who live in it. In order to give effect to this belief and to give substance thereto, the Bill of Rights sets out in Section 25 the entrenchment of property rights to those who already own property, and how, in the public interest, inter alia, land reform will be pursued in order to bring about equitable access to land and all other national resources. In our considered view, in order for the state to be able to deprive an owner of their ownership of land or any other property in pursuit of fostering conditions which enable citizens to gain access to land on an equitable basis, as enjoined by the Constitution, it can do so only in terms of a law of general application. In order for the new law, which enables expropriation without compensation, constitutional scrutiny, the Constitution itself has to be amended accordingly. As stated in our main submissions, in our view, Section 25 does not permit expropriation without compensation. Subsection 2B stands in the way of any reform steps that the state may apply under subsection 4 to 8. We conclude, therefore, that subsection 2 is peremptory in its provisions that property may be expropriated subject to compensation to those affected. The amount of such compensation has to be as agreed by those affected or decided or approved by a court. Furthermore, subsection 3 is clear in its provisions that having taken the factors listed thereunder, the amount of compensation must be just and equitable. We therefore say Section 25 does not permit expropriation without compensation. Paragraph 3, the question is who works the land? In this section, we seek to destroy the myth that Black people are not interested in acquiring land ownership or other forms of secure tenure because they are unable to or have no interest in farming or other land-based industry. In the classic, The Seed is Mine, the life of Cas Maine, a South African sharecropper, 1894 to 1985, Charles van Onselen tells the story of a man and his family who successfully worked the land as a sharecropper for 35 years, but who died a broken man because apartheid laws made it impossible for him and his family to survive as farmers. He describes his work as a sharecropper as follows: the seed is mine, the plowshares are mine, the span of oxen is mine, everything is mine, only the land is theirs. This description of a Black sharecropper is repeated in Sol Plaatje's book, Native Life in South Africa. In our submission, therefore, first, that from these two authoritative sources and from other sections of the main submission, it is a myth that Black people do not have the skills nor the desire to work the land in a self-sustaining or profitable manner. Paragraph 4 is why expropriation without compensation. 1, the primary reasons are the inability to effectively provide meaningful redress for Black people who were dispossessed of their land rights under colonialism, apartheid laws, policies, and practices. The fact that ownership of land and other natural resources is heavily skewed in favor of private owners, and that the state cannot possibly afford to buy the land required for reform and restitution. There are other 2 factors that we list. Systems of land tenure, paragraph 5. The 1994 Compromise on Property Rights resulted in the abandonment of the foundational ideological departure point of the struggle to restore the land and its other natural resources to the people. Instead, the rights of those who had become owners through conquest and apartheid laws were entrenched through the adoption of the owner dominion-centric ideology. However, we submit in order to achieve the Constitution's transformative vision to foster conditions which enable citizens to gain access to land on an equitable basis and to bring about equitable access to all South Africa's natural resources by all citizens, different systems of land tenure must be adopted. Each system will be appropriate for the purpose that the land or resource is used. To preempt a question of expropriating property that black people own, the answer is that they too will have their ownership converted to appropriate tenure for their purpose once the land is nationalized. The land tenure and property rights can take the form of freehold, leasehold, public rental, private rental, customary, aboriginal, indigenous, or indigenous in origin, national or international heritage. The recommendations on legislative changes will be dealt with by Comrade Ashraf Mohammed, and we propose both a text for the amendment of Section 25 and the principles that will underlie new legislation. And finally, at paragraph 7.2 under conclusion, both Section 25 and national legislation must entrust ownership of property under the custody of the state or provide for a neutral and independent land commission whose function will be to develop policies appropriate to various systems of tenure, appropriate to the purpose and or use of land or harvesting of other natural resources. I pass on to Comrade Ashraf.
Comrade Ashraf, you have 3 minutes.
Thank you, Honourable Chairperson, honourable members. Thank you. I will simply deal with, in very succinct form, the recommendations on the constitutional and legislative changes that we propose. And specifically, what I will do is I will start with some of the principles of legislative changes and then move on specifically to the section that we propose should be amended in Section 25, the subsection. I hope that honourable members have received this particular sheet, and I basically will be referring to that. The first principle we believe is necessary for the legislator to consider is that there's a need to ensure that the core individual dimensions of the right to property is respected, protected, promoted, and fulfilled in terms of Section 7, subsection 2 of the Constitution, but that it is balanced with the social dimensions. And when you look at Section 25, what we are saying in effect is that there's a structural imbalance, that it is in favor of the of the personal functions and the individual functions, but it doesn't focus sufficiently on the social functions of or dimensions of the right to property. And so we believe that the amendment that we propose will emphasize the social dimensions. The second point is that the right to compensation should be restrained by community norms and values and ethical principles and made subject to the overall welfare of society. And if you introduce the social dimension and you emphasize that or elevate that with the amendment that we're proposing, then you will begin to see how the interests of society or the interests of the public or a public purpose becomes more elevated and more important, because the concern for the legislator and of government in particular is the well-being of society. The primary point there also being that it is directed towards the economic, moral, and material upliftment of communities, and that is the central thrust of that particular point. The third point is that the standards for compensation in Section 25, we believe, and the law of general application, which we believe is necessary, because you want to first amend the section in the Constitution before you look at an amendment to the Expropriation Act, that there must be some level of flexibility in that regard. We believe that Section 25 and the law of general application should not be interpreted to require compensation for property taken where this property was acquired under the apartheid order. And here I'm specifically talking about land not necessarily falling under the restitution framework, but which may have fallen outside of that, but which has not been identified.
The time has lapsed, Mr. Mohammed.
Okay, thank you, Honorable Chair.
Thank you very much. Clarity-seeking questions? Honorable Mutsecha, Honorable Swart, Honorable Carter, in that order.
I haven't had anyone specifically addressing the question of the cut-off date and whether or not we should not distinguish compensation for land and compensation for improvements. What would be your view on those two issues?
Honorable Swart.
Thank you for your very useful submission and lengthy submission, which I have read. Given the fact that there are various legal opinions on Section 25 and whether it is, as presently worded, whether it allows expropriation without compensation or not, is it not advisable to approach the Constitutional Court as step one to enable the Constitutional Court to give the parameters of the presently worded Section 25? And secondly, given your view that Section 25 must be amended, would you then agree that the founding provisions as well would require an amendment to facilitate your position? Thank you.
Honorable Fultana.
Thank you very much, Chair. I have to say that this is one of the best presentations I've had so far, from my perspective, because there is no unjustified bias in any direction, except that, of course, you are suggesting that Section 25 needs to be amended, and you speak succinctly to the purpose that would be met. So am I right to interpret you to be saying that the form of amendment should lead to the following classifications of land use? That is for social purposes, for economic needs, as well as for public purposes. Is that the trend that you think, where the expropriation should be following? Thank you.
Honorable Carter.
Thank you, Chair. Just in your view, do you think that the failure was actually the failure of Section 25 of the Constitution, or do you think it was an implementation of Section 25 of the Constitution? Now, I also want to thank you for your presentation, a really good presentation. But I want to get to the question that specifically, how do you feel about it? Because I'm not getting it out of a presentation. When we're talking about expropriation without compensation, what about the 4.2 million hectares of land that has been purchased and owned by black owners who bought it with their own money, monies that are bonded? How would we deal with that money or that crop repayments that needs to take place? Then I'm a little bit confused, because some places you talk about property and some places you talk about land. So there could be a very distinctive difference between what is property and what is land. And so if you can maybe just define that. What do you mean with property and land? Thank you.
Honorable Korenov.
Thank you very much, and thank you. It's always good to listen to lawyers. In your submission in paragraph 125, you deal with the amendment to Section 25(2)(b). What I want to ask you, are you happy to include, not to include, but are you happy that judicial review must remain at all times? So you're not excluding judicial review in terms of a aggrieved partner. And then secondly, you're talking about this property, when property was acquired, and I quote, under the apartheid order. I just want clarification on that. Can I just make a simple example? If I have bought property in 1993 from someone, say from that gentleman, is that property acquired in terms of the apartheid order, or are you talking about legislation and what we all know what happened in this country previously.
Nadel, replies.
Thank you, Chair. Ashraf will deal with most of the questions. I just want to deal with the first part of Honorable Swartz's question. We don't think it is desirable that the legislative function of this body should be passed on to the courts to give guidance. This body has all the mechanisms to ensure that if they amend the Constitution and pass legislation to give effect to that amendment in the Constitution, it must go through all the necessary steps that this body will know to go through to ensure that it passes legislation that passes constitutional muster. So we will urge this body to be the one that does that rather than pass the buck, just like we did with the death penalty. We shifted the responsibility to the courts instead of us doing it here as the legislature. I therefore suggest that the role of the court will be to scrutinize the constitutionality of the constitutional amendment that this body would have made and accompanying legislation to give effect to Section 25.
Thank you, Honourable Chair, Honourable Members. Honourable Machecha, you asked about the cut-off date and the issue of compensation for land versus the issue of compensation for improvements. I believe that as far as the issue of compensation for improvements are concerned, there is an existing legislative framework or statutory framework that deals with the issue of unjustified enrichment in respect of improvements. What we're dealing with specifically is the issue of land, and more specifically the challenges around land and the welfare and improving the quality of lives of people in both rural and urban areas. And so we believe that that distinction is a legitimate one, but there is a framework for dealing with improvements. With regard to the cut-off date, I think the broad thrust of our submission is that we're not just dealing with the period between 1913 and 1998 or beyond that. You remember with the Richtersveld judgment, we embraced the notion of Aboriginal title. And so even before 1913, the issue of dispossession under colonialism does feature as part of our legal framework. And so I think that it will be appropriate for the legislature to look at that in a broader sense, in a wider sense, as well as far as the cut-off date is concerned. Then, Honourable Swartz, I believe you've raised the issue of the challenges in the Constitutional Court. The difficulty with that, Honourable Swartz, is that we believe that the legislature is the more appropriate institution to look at broader political, social, and economic considerations, because you have to strike a balance. Courts, as you know, tend to deal with matters before them on a factual basis. You can only make good law out of good facts if you argue a very good case in court, and many of you are lawyers will know that. So we believe that it is actually appropriate for the legislature to consider and to strike that balance, mindful of what the needs are in society at this present juncture, and to take all of those things into considerations. I think your question about the founding provisions in the Constitution, I don't think we're necessarily going there. We're saying that shouldn't be fettered with. Those remain the key foundational principles, the rule of law, the supremacy of the Constitution, access to justice, access to courts, etc. All of those things must remain in place. But to the extent that we are talking about amending the Section 25, we're saying even with regard to the amendment of Section 25, leave the core component of individual property rights in Section 25 in place. And you'll see from the amendment that we've proposed, we're simply adding an additional component that elevates the social functions of property and allows the state to emphasize the welfare of society so that it can allocate the necessary resources to uplift communities and attend to the socioeconomic needs of our communities, etc. And then the issue about expropriation for a public purpose and the public interest, I think that has been dealt with in our submissions. We believe the central thrust remains in Section 25. It is provided for in Section 25, subsection 2A, but we simply wanted to broaden that by elevating the social functions of the right to property. And then the problems with implementation, honourable members raised the issue. There are difficulties with implementation. It is well known, it has emerged out of various case law and submissions before yourselves, that the Department of Rural Development and Land Reform and the Land Reform Program as a whole, with its land tenure program, restitution and redistribution programs, has not achieved the objectives that it was meant to achieve. And so there are difficulties with implementation, but we believe what we need to do at this particular juncture of our constitutional democracy is that we need to unlock other mechanisms to facilitate land reform and redistribution in a more proactive way compared to what we've done thus far, because that has also created a bit of limitations. Your point about the 4.2 million hectares of land which has been purchased by black owners, I think it's a point that you've made. I don't necessarily want to respond to it, but because there is a sort of like a subtext to what you were suggesting there as well. I think my colleague has already addressed the point that it would be inappropriate to suggest that because black people have received the land, they cannot manage the land or run or be effective black commercial farmers, for instance, in that particular instance. But that is not necessarily land that should be the subject of expropriation. I think more support needs to be provided to those farmers to make their farming operations more successful. The honourable member raised the issue of the distinction between property and land. It's a valid distinction as well. What we tried to emphasize was that the Constitution in Section 25 provides for property, but we were focusing in certain submissions specifically in relation to the land reform program and the challenges that were faced with it, so that we were mindful of that distinction, but we specifically wanted to address certain submissions in relation to the weaknesses in the land reform program. And then the final question around judicial review. We believe, honourable member, that judicial review must remain part of the legal framework. It is a necessary check and balance that we need as part of the system, the legal system in South Africa. And then your last question was a property that has been acquired under apartheid. We understand, and you raised the example of property that you may have purchased in 1993, I think, if I heard you correctly. Now, most of the edifice of apartheid would have been eliminated by then, like the Group Areas Act and so forth. But we still live with the legacy of apartheid. And so many people have been excluded from benefiting from the opportunities in the new dispensation that we have. We need to address that. And to the extent that people would have acquired properties, even on that cusp, on that threshold, if they did benefit under apartheid, then so be it. It should necessarily form part of the legal framework of an expropriation or a compensation approach. Thank you.
Honourable Shivambu, conclude for us.
No, a quick one, Chair. I think we must appreciate that both organizations that represent black legal practitioners, the BLA and NADEL, are presenting progressive submissions. But I want NADEL to simplify something for me. So in your conclusion, you say that NADEL submits that a case has been made for the Constitutional Review Committee to commence or recommend the process of amending Section 25 to unequivocally permit expropriation of land and other natural resources by the state without compensation. That is clear. And then in 4.13 of your submission, you speak about the custodianship component. You say the fact that land, water, and other natural resources are not infinite resources, property must therefore reside under state custody or under a neutral and independent state agency, such as the Land Commission, which will have certain functions. I think those two submissions are progressive and clear. But in terms of your rewording of the Constitution itself, the second component says that if subject to compensation, the amount and all of those things that are in the current Constitution. So what then are the cases or components or circumstances where there will be compensation? Because your overall perspective is that we should not have compensation in the expropriation of land. So under which circumstances are we going to have the compensation as is implied in your Section 25(2)(b) recommended wording? Advocate Senior Counsel Malindi.
Thank you, Honorable Shibamvu.
As you conclude, Nadel, you'll reply as you conclude.
Thank you, Honorable Shibamvu. A quick example is once land is nationalized and there's a person or a company that runs a forestry industry. And in terms of the various forms of land tenure that we propose, and my learned friend will do so shortly, we may say your right to freehold has been taken away, but you are given tenure or a lease of 50 years, because we know you harvest your first tree after 25 years. We say you're getting 30 years or 50 years or 99 years, and there may be an element of compensation, for example. Or someone who has built a house, but the land on which the house stands has now reverted to the state. There may be an element of compensation, and my colleague here will conclude on the various forms of tenure that we have up on the screen.
Thank you. Ours is to say that no person should be afraid of expropriation without compensation, because the rights and the benefits and the use of land will be given to people in terms of systems of land tenure: freehold, leasehold, public rental, private rental, aboriginal title, or international heritage. I want to draw your attention to pastoral leases. 44% of the land in Australia is leased to farmers. That land is owned by the Crown. It's the same case in the United Kingdom, where 33% of agricultural land is leased, and the Crown is the only owner, freehold owner of land in the United Kingdom. We should look at the example of Mozambique. In Mozambique in 1997, land was nationalized. People acquired the right to use and benefit the land. Nobody is conferred a right of ownership, but you have leases that go up to 50 years. What they've managed to do in Mozambique is they've managed to stabilize their currency. It's one of the most stable currencies in the world, and they've been able, under the same system, to attract foreign direct investment. It's a unique example, it's an African example, and it's an example that South Africa needs to look at. Thank you.
We therefore thank the Democratic Lawyers, National Democratic Lawyers Association for your presentation and making yourselves available to participate, to enrich this process. We thank you very much.
Thank you very much,
I think we
Chairperson
must
and
state
honorable
that
members.
Nadel is the future.
It's not the committee's view, right? All right, our next presenters is the Apostolic Faith Mission, AFM. As you prepare, or as you get ready, you'll proceed. AFM, are we here? Oh, all right.
Coming live to you from those Constitutional Review Committee hearings into land expropriation without compensation. We've been hearing different points of view throughout the day, both people who are very pro and against. We've just heard some lawyers setting out the legal benefits and disadvantages of land expropriation without compensation. It's time for a short break. I'll have more news for you when we come back. Do stay with us.